to the third part of our three-part webinar series on data privacy, sponsored by EY. Today's session is entitled Data Privacy and Cloud Management. I'll be your host and moderator for today's session. My name is Donna Bales, and I'm the founder of the Canadian RegTech Association. For those of you who do not know the Canadian RegTech Association, we're a not-for-profit focused on solving regulatory challenges through collaborative efforts between key RegTech stakeholders, the regulated entities, the technology vendors, and the regulatory bodies. So this is the third part, and we've had two initial parts. Our first part of the series focused on the legislation. We had Dominic Payette from National Bank of Canada and Christophe Bernard from Weigelt. Weigelt is a boutique legal firm in Europe. And in this session, we took the legislation and we compared the Canadian proposed legislations with GDPR from a privacy by design perspective. In our second part of the series, we looked at more from a practical angle. And we had three of our founders from RegTech firms within our community discuss how they are embedding privacy by design principles within their products. So Data Sentinel, Prodego, and QNex, the founders of these organizations discussed the challenges and gave us an overview of what you can expect from their products. If you've not had a chance to listen to the replay, I really encourage you to do so. Today, we're examining the theme of data privacy from a data management angle. Protection of customer data is central to the privacy laws, but as we all know, the data is not static. We share it, we store it, and it's being used for multiple purposes: regulatory, business insights, to purchase, and to enroll. I have an expert group of privacy experts with me here today, and the intent behind this session is to look at the privacy laws from a data management perspective, examine some of the challenges, and discuss the impact of the proposed rules on companies' relationships with their service providers and cloud data management. So I'm going to just make a brief intro to the panel. We have Myron Mallia-Dare. He's a technology and business lawyer at Miller Thomson. He's also an advisor at the CRTA. Carlos A.P. Chalico, who has multiple accreditations in this area, and he's in the privacy and trust practice at Ernst & Young. And John Weigelt, the National Technology Officer at Microsoft. So welcome. And to kick things off, I thought I'd let each of you expand a little bit on who you are and your expertise in this area, and also answer the question, just to get us level set here, what your view is on the current state of the privacy laws in Canada. And Myron, we'll start with you.
Thank you, Donna. I appreciate the introduction there. So as Donna mentioned, I am a corporate lawyer at Miller Thomson here in Toronto. My practice predominantly focuses on supporting technology companies throughout their life stages. Within that is negotiating complex technology transactions with a focus on emerging technologies such as AI, blockchain, and a lot of work in the cloud. So I'm glad to be here, and thanks for the invite, Donna. So no, I think it's a great question to kick things off. And it's kind of a question that probably could take an hour in itself. It's what's the current state of privacy laws and where we see these going as well. So I think right now the existing framework, and we'll get into it a bit in a later discussion, is it's a bit of a patchwork right now, where we have different legislation applying to different industries, but the predominant one we'll be discussing is PIPEDA, which is the federal privacy laws that applies to commercial activities. Now, within that, it's a law that has been around for a while. It's technology neutral in its form, and it's principle based as well, but it was designed in some ways for technology of the past. So even predating mass adoption of cloud computing, and We've seen changes throughout the world of different jurisdictions realizing this and coming up with replacement laws that are maybe a bit more customized to technology and not only present day looking but forward looking. So I think the landscape right now of privacy laws in Canada, at least, is it's time for an update, and there's to really reflect technology and also to be a bit more forward looking.
Perfect. Thanks, Myron. And we'll get deeper into the legislation shortly. John, please introduce yourself.
Hi, everyone. I'm John Weigelt. I'm Chief Technology Officer for Microsoft in Canada, as you heard earlier. And I am accountable for helping organizations really see where technology is moving. And so I help digital transformation across the country with all customers. I also work at that interface between policy and technology. So try to make sure we avoid those unintended consequences. So spend a great deal of time in security, privacy, accessibility, responsible AI, topics such as that. I'm also accountable for the compliance of Canadian data centers, so demonstrating how we help customers maintain their compliance of those communities. And that comes as a result of some of the work that I previously done at Treasury Board Secretariat in the federal government. I've been around for a while, clearly, because I helped draft some of the less germane parts of PIPEDA for the conversation today. I was more on the Electronic Documents Act. And when we looked at drafting that legislation, there was really this 10 to 15 year time horizon for that legislation. You really want it to last for a long time. So there's a couple of characteristics that happen when you create legislation like that. One is that you write in purposeful ambiguity. And so you leave some room for interpretation because you know that things will adjust and change. The second piece was the principles-based approach. And that principles-based approach really stood us in good stead for a long time. And I had the opportunity to talk with international governments around the Canadian approach to privacy back in the day. And there was a strong affinity for taking that approach that we had adopted from the OECD. But as Myron mentioned, as time changes and we see that there are new threats to our privacy, then the legislation needs to change. And we've seen different jurisdictions move around the world to enhance their legislation. From an international organization perspective, we're always encouraging this idea of harmonization. And certainly when we look at the Canadian financial institutions and others, they're global in their nature. And having to comply against a variety of different privacy regimes can add complexity and cost to services.
Perfect. It's so great to have your perspective today because you've seen the journey right from the last update. So welcome to today's session. Carlos, how about yourself? Tell us a little bit about yourself and your view on the current state of affairs.
Yeah, sure, of course. Thank you. First of all, thank you so much for the invitation. It's an honor to be here with you, Donna, with Myron and John, and thanks to everyone that has made the time to come. And I'm born and raised in Mexico City. I became the partner in charge of cybersecurity and privacy in 2006. Left EY in Mexico to move to Canada in 2012 to come and enjoy the winter. I'm still having fun in the winter. And when I moved to Canada, I was working for a couple of companies in addition to, well, instead of Ernst & Young for a couple of years. One of those was Nibity, a company specialized in privacy matters and had the chance to help companies in the States, in Europe, and in some other regions in the world to deal with privacy matters. So my journey in privacy started in Mexico in 2009 and hasn't stopped since then. I am very passionate about privacy because I think it is one of those disciplines that brings together different things. It is not only technology, it's also regulations, of course, and it is also behavioral situations on the side of the employee, and on the side of the consumer. So the combination of factors make up this something that is very, very unique. So this is something that I have definitely enjoyed. Now, what I think about Canadian regulation or Canadian legislation, I think that Myron and John have said everything right now, but I want to emphasize the need of reinforcing and renewing privacy legislation. There's a couple of events that I want to bring to our attention just to have more clarity on how all these regulations are. I am talking about the federal regulations for government and private sector. The two events are the launching of the Commodore 64. I don't know how many of us are old enough to remember a Commodore 64. I used that computer when I was very, very young. That happened in 1982. And the second one is the crisis of year 2000. I remember that I recently was talking to a couple of very junior colleagues of mine at Ernst & Young, and we were just discussing about some compliance and challenges that corporates face. And then I mentioned year 2000, and the two were just looking at me with these eyes, like asking what happened then. And one of them said, what happened in year 2000? And I said, you're kidding me. You don't know what happened in year 2000? And one of them said, well, I was 3 years old. And I said, well, okay, now I feel old. So I am saying that because the Privacy Act, which is the one that is defining the rules for the government in Canada, was released in 1983, was enforced in 1983, just 1 year after the Commodore 64 was released to the market. And in the case of PIPEDA, it was enforced in 2000, which was exactly the year when we were just waking up from this nightmare we had before year 2000. So I think the two of these regulations are great. They have served a purpose, and now it's time for us to move forward, because we have seen that the world is changing, globalization is moving us forward, so we need to do the same. So that's my expectation from privacy regulations, to finally respond to what the world is demanding.
Yeah, the time is now. So let's dig into a little bit into the rules and look at them in terms of how they are laid out in terms of the relationships between companies and their service providers and cloud data management. And Carlos, I know you just spoke, but if you could maybe start us off on this topic.
Yes, of course. You know, the way Myron was describing how our regulation is today was pretty accurate. What we have right now is a series of patches of multiple regulations to cover different needs. So as I was explaining, we have the regulation for the government, that's the Privacy Act. We have the regulation for the private sector, that's PIPEDA. And we need to keep in mind what John was saying. PIPEDA is in fact a couple of regulations. We have the first section, which is the Personal Information Protection Act, I can say. And then the second part, which is the Electronic Documents Act. So we have a couple of regulations in one single volume. That's at the federal level, defining how companies have to be dealing with privacy. And I am just trying to think as well that the complexity of our system is that PIPEDA is even defining some additional rules for federally regulated businesses. And there are some other specific that are going to be impacting provincially regulated businesses. So precisely to respond to that, we have some provinces that have decided to create their own privacy regulations. And that's how we have the Personal Information Protection Act in Alberta, the Personal Information Protection Act in British Columbia, there's the Privacy Act in Quebec, and we have some other provinces that have gone for specific regulations that are going to be taking care of personal information managed within the healthcare sector. So when we think about privacy, we tend to think about PIPEDA, perhaps CASL, which is the youngest of all of these regulations, but they are not the only ones. And if we go to other regulations within very specific sectors, within very specific topics, they also have something to say when it comes to privacy. Now, the concern that comes to my mind again, thinking of the patchwork we already have, which is challenging in itself, is how old it is. Something that we need, of course, as a country to keep moving from the economical perspective is to be inserted in the global economy. And one of our most important allies is precisely the European Union. So PIPEDA was recognized and respected as a solid regulation in early 2000s when it was released, because it was somehow following what Europe had defined by that time under what was called the 1995 European Union Privacy Directive. So because of that, Canada, as some other countries in the world, is considered to be adequate from the privacy perspective in terms of being enabled to have exchange of personal information with the European Union. Now, the challenge we are facing is that this status of adequacy that was granted to Canada in early 2000s was granted as a result of how PIPEDA was aligned with the privacy directive that was released in 1995. Now, the challenge is, as I was saying before, that we have evolved, the world has evolved, And the privacy directive is not in use anymore. What we have in Europe is the GDPR, the General Data Protection Regulation that was enforced in 2018 is creating new principles, new rights, new challenges, and it's trying to recognize new technologies in order to respond to these needs within the personal information protection field. Our current regulations are not responding to that. So we need an evolution in this regulation to properly respond to this, to keep our status of adequacy with the European Union, and to be ready to respond to what the world is saying. And I think that's what I can say in terms of what we are having right now and what we will see. I will reserve the changes that we will see happening in Canada for what we are going to be discussing across this session. But I think that's what I can say to start discussing where we are standing right now. And I would love to hear what John and Myron have to say on this.
Yeah, like the intent behind, like the technology has moved enormously, in the last little while. So, John, maybe you can add on to this. Like, what do you think was the intent, when C11 updating in terms of accommodating the changes in technology and in the relationship with service providers?
So I wouldn't want to speculate on what the intent was behind the lawmakers and what they were hoping to do. Certainly, I think to lean heavily onto what Carlos had indicated, the concern around adequacy and being able to support that free trade of information or meaningful trade of information between the European Union and Canada, and to continue to drive economic opportunity between the regions, because getting carved out of that would be quite a challenge. I think one of the big challenges we have anytime you look at modernizing legislation is adopting that new frame of reference to where the technology has moved to. Cloud computing has dramatically changed the way that people look at computing, and we still have a mindset in regulation around an outsourced service provider, where you have a formal contractual relationship with the organization handling one monolithic type environment. And what you find is that in some of these new cloud models, it's simply a service that you're collecting, a generalized service, where you have the generalized terms and conditions. Now, the great news is that the cloud service providers do meet that high bar for privacy established by GDPR or Schrems 2 or California. And so you have that consistency. The trick will be then, as you look at the new legislation that comes out, how do you map it against those existing control sets and those existing control families? And as a practitioner in this space, it's really, really critical that you understand the control sets that are behind the scenes, because some of these standardized audit controls are still based on very, very dated type of mindsets. And so the richness that you'll find in a cloud service, privacy and security in the checkboxes. And so when you think about the administrative controls like just-in-time access, multi-factor authentication, like all these different technical controls that safeguard privacy, they don't fit in the checklist. They have to be put up in the system descriptions. And so if the regulation is based upon those previous models, then it falls short. And that really then speaks to this idea of really keeping a principles-based approach. Mm-hmm. There was some regulations that were coming forward and had bumped along for, I got to say, 8 to 10 years, just because they came forward, they got voted down, came forward again, got voted down, and they were talking about regulations around fax machines. And yet in this particular community of interest, the fax machine had fallen into disuse. So we're not talking the medical communities where fax machines still have a strong play, but in other communities, how many of us have sent a fax in the recent time? I haven't in the last recent history. And so why come up with regulations that talk to that specific technologies? We've seen there's pitfalls in doing so.
Yeah, exactly. It's interesting. You mentioned global opportunities, and so I wanted to link that back to you, Myron, because you mentioned earlier kind of the patchwork of the proposed legislations. The provincial laws versus the federal laws. So what do you think, keeping this kind of patchwork legislation environment that we seem to be in, what do you think that could mean in terms of global opportunities for Canada and innovation more broadly?
That's a great question, Donna. I think just dialing it back a bit to build on Carlos and John's comments when we're talking about the patchwork here is it's not even just a discussion about an industry. There's many multi-factor layers to this. So it's a jurisdictional discussion about where the individual resides, who the personal information relates to. So that's where you see the PIPEDA versus the provinces where there's substantially similar laws passed. So Quebec's, Alberta's, those are the provinces there. Now, on top of that, the next layer you have to contemplate is what vertical does the company operate in? Because there's health-specific privacy laws, as John just alluded to as well. There's also laws that relate to certain industries. So if you're in the nuclear sector as well, the laws will apply differently, and there's different requirements and nuances under each. And each province within the health privacy space has enacted their own laws, which again have their own nuances too. So there's many discussion points you have to be aware of when doing business in Canada from a cloud provider's perspective, from an intermediary's perspective as well, that organizations need to be concerned on. And I think this goes to John's earlier point, which I think is great, it's harmonization. Because you can imagine if you're a consulting company doing work for an intermediary whose client just so happens to be in the nuclear space, those obligations start flowing down to you, and data is getting treated differently from all of your customers. So even with these new proposed privacy legislations that are coming in, they're still only targeting a specific sphere of data, which is commercial data used in a commercial purpose for a private entity or a federal undertaking. So that's really the limitation here. So although we're seeing all of these changes, and in the consumer context, we're seeing new privacy laws coming out, which are going to match up with, in some ways, GDPR, and in some spaces, which we'll discuss, go a bit further, such as in automated decision processing, you're still in this patchwork state. So it becomes an issue for a non-Canadian or even a Canadian provider of an innovative technology or service, because they then have to come to Canada and say, well, we're going to be going to a province with 1 million or less than 1 million potential or population. So you can then really work out what the customer base is. It could be nominal. So you start seeing vendors looking at jurisdictions and saying, maybe I don't go to Nova Scotia, or maybe I don't go to another province too. So that's a brief overview of what the patchwork is and some of the issues we typically try and solve for when we're dealing with both the cloud provider, vendor, and intermediaries too.
The trade implications are very fascinating, really, like when you start thinking about it, like, and it's a little off piece to our audience, but like when you think about that Internet of Things, and you start embedding technology within products and trading them internationally, like there's implications there. And Carlos, I don't know if you wanted to expand on that, because in our prep session you were talking about the free trade agreement, and what that implies in terms of cross-border considerations.
I'm sorry, was that for me?
Yeah.
For Myron? For me, sorry. I think I was a little bit distracted. Yeah, no, you're absolutely right. I think this need of transferring personal information internationally is fascinating because of the multiple complexities you can find. I have been working with clients in Canada that have operations in different countries, not only in our country, and how they interact and how they define mechanisms to properly protect this information is, of course, challenging. What happened with the Privacy Shield and this Ernst situation that canceled that specific model was, of course, a challenge for companies in the United States to change information with the European Union. So we need to pay attention to where our company operates. As Myron was saying, where the consumers we are interacting with are residing, so that we can decide which rules are going to be applicable. Now, beyond the rules themselves, I think we need to recognize as a country, as we were mentioning before, how we are connected to the economy in the world. And something that we need to keep in mind, the recently reapproved National Free Trade Agreement, or excuse me, North American Free Trade Agreement, the NAFTA, this agreement between Canada, Mexico, and the United States, has something that to me seems very exciting. And this is Chapter 19. Chapter 19 within the CUSMA, the Canada-US-Mexico Agreement, is specifically devoted to a creation of a digital market. This digital market is somehow similar to what we have as the single market in Europe. So that's what I think is fascinating. And the way it was written for the agreement, defining how these three countries are going to be pushing for the creation of this market is very exciting. I think I am an optimistic, but I think that this is going to be creating a lot of opportunities for everyone. Now, what makes it even more exciting is that among the multiple rules included in Chapter 19, there's three that are directly related to what we are discussing right now. Number one, cybersecurity. The chapter is trying to define that the three parties involved in this agreement, that's Canada, United States, and Mexico, need to define similar rules for cybersecurity, but it doesn't stop there. It goes to request the same for consumer protection, and it goes for the same in personal information protection. So that means that the three of these countries, in order to enable this digital market, need to try to push for rules that are very similar in these three arenas, in these three fields. And that's, again, another very good reason, I think, for Canada to think of renewing legislation, because we need to find a way to properly push for the development of these operations. And I am just paying attention to the North America Free Trade Agreement, but it is not the only one. We have other treaties with other regions in the world, with other economical coalitions, and we need to be ready to properly respond to that.
Thanks, Carlos. I think each one of these sessions, they seem to fly by because there's so much to say. So I'd like to flip a little bit now and get a little bit deeper into what it means, to a financial institution, and some of the sort of the more practical challenges. So John, I want to take it over to you now. So there, when you talk about cloud data management, we often talk about shared responsibility between financial institutions and the service provider. Can you talk a little bit about that in terms of will the new laws have any impact on third-party relationships and how these relationships are negotiated and contracted?
That's a great question, and I think we look at the Canadian financial services marketplace and even the international financial services marketplace. We've been having compliance conversations since we announced the cloud computing some 13 years ago now. When we announced Red Dog, it's hard to imagine it's been that long. And so we've evolved our agreements with the financial institutions to understand what their privacy requirements are, and then to be able to paint that picture right from our online services terms to our data protection addendums, and then through the contracts that they have in place, so that there's a clear understanding of who's the data processor, who's the data custodians, and what those respective roles and responsibilities are. There is a shared responsibility, and so financial services organizations can make use of those built-in compliance regimes and compliance assertions. The regular audits that are done either through the SOC 2 or ISO or any of the many international audit requirements will stand that financial institution in good stead. We've also worked closely with the regulator, and recently with OSFIs and their consultation around digital risk, and even prior with their B10 guidance and whatnot, helping organizations understand materiality of information. What does access actually mean? What's that purposeful ambiguity, and how do you manage that? And we've seen Canadian organizations get comfortable with their usage of the cloud as well, so that they understand how the contractual requirement fits in with the technical requirements. And then we'll talk a little bit later about the technical side. I can dive into that, of course, as CTO. Can't wait to get into the technology conversation. But we just see that there will be an effort to have another look at those existing contractual arrangements and make sure that they all continue to comply.
Yeah, I think it's a good timing. That B10 is going to be updated, in line with these new laws, and I think we're expecting that in the first quarter next year. So we'll probably have a follow-up session on that. I would expect in the coming months. It was really interesting in our first session. Dominique Payette, she described data privacy as being a business risk. And so I'd just like to get the panel's view. Do you agree with this? And what do we think firms need to be thinking about in terms of managing data privacy risk? Myron, can you start us off on that discussion?
Yeah, no, I'm happy to. So I do agree with that point too. And I think at least when we're thinking about data privacy compliance, it needs to be more than just a sub-thought of the privacy officer or something that gets hived off to certain departments. And this is going to become even more so with the new privacy laws, because there's going to be specific requirements with respect to operational matters. So if you're thinking about any kind of automated decision making, or there's a requirement for algorithmic transparency here, and it goes even further than what we have under the GDPR, which is data process for automated decision making is covered under the GDPR, but under Canada's proposed laws, it's going to be any data that relates to that processing. So it's an even broader application here. So you really need to, if you're an organization, take steps to not only understand compliance from a risk perspective and taking on risk where you do, but you need to foundationally take into an awareness in the product development design lifecycle. Privacy by design, we've been speaking about that for many, many years, and it becomes more and more important when you have new obligations and rights being built into the Act for data portability and items such as that too. So yes, it is a business risk in itself, and I think to recognize and reflect that business risk, the right stakeholders need to be involved in those conversations, from everyone from the CTO, from the technology side to the CEO, because it's one thing to just say the privacy group will deal with this, but then the issue is the privacy group doesn't know what risks to take or how to dissect that risk too as well. So it's either it becomes the Department of No, or they're taking on unknown risks that people in the organization, if they knew the business reality, probably wouldn't want them doing. So that's really my thoughts on that too.
Yeah, I think with all these opportunities to use new technologies like AI, it really has to proliferate within the organization. Carlos, do you have anything to add on that in terms of how firms should be managing this from a cultural perspective?
Yeah, you know what? I definitely think it is a business risk. So I am completely in line with what was said in this and in the previous presentations of this series. But I think we need to go beyond that. I think that privacy should be considered as a value generator. I think we need to see beyond compliance and start identifying how privacy can help us create value for the organization. Something that is pretty interesting is to see how this lockdown that we are living all around the world is making us think differently about how our personal information is being managed. We recently made in the firm a study that was helping us understand how the oldest cohort within Generation Z, this is people that is between 18 and 23 years old, was thinking about what they expect from the world to come. And what they are expecting is to have organizations that are more human and that are putting the individual at the center of the conversation. And we think that privacy is a perfect vehicle for doing that. If you, as an organization, start realizing that your clients, your employees, all of the stakeholders that you interact with have to be at the center of the conversation, and that you need to think of how to respond to their expectations instead of just responding to those from the shareholders, and you have a focus that is more human. We think that there can be opportunities as well to link privacy to CSR, that's corporate social responsibility, or ESG, environmental, social, and governance, just to show how privacy is delivering this value and to make it clearer for anyone. So we think that we can go beyond compliance to think of value generation and value preservation. Now, in terms of the integration of these elements within the culture, I think we need to work with people across the organization to try to embed this concept of privacy by design within the organizational culture. If we want privacy, trust to be considered in the design of every single process, in the design of every single application, that means that we need every single person within the organization thinking about privacy, excuse me, so that when they come with ideas to create new solutions for existing or new problems, they can incorporate into that how trust is going to be created, so that before the process or the application is released to the production environment, we have something that is solid from the trust generation perspective, and that will help the organization not only comply with privacy regulations, but generate value through this creation of trust. That's how we see it.
Yeah, it's I totally agree with your comments. It'll be so important, and I want now to just flip it a little bit to the audience to get their views. We've got a poll to see who they think are the major stakeholders responsible for compliance. So the question is, which stakeholder in your organization is primarily responsible for privacy compliance? So that's privacy officer, CTO, CEO, all of the above, or other. So not really a trick question after the comments by our experts here. So we'll leave that for people to answer. And we'll move on to the tech, as John because this is really important, because really, if we go back, we want to talk about what is the impact of cloud on privacy technologies. So John, can you kind of pick this topic up and tell us what your view is on the impact of these laws on the cloud?
Well, I think when we start to look at the technologies that are involved, technologies have come light years from where they were when we started these conversations. When we think about that frame of reference that we had in the past, it was that desktop computer or that server in a closet that kind of framed that conversation. This was before the social media companies and the large retailers gathering these large resources. And so it starts, I think, right from the data and having a proper understanding of data. I often hear mischaracterizations of data being the new oil. Well, oil is a finite resource. We keep making new data. Data is temporal as well. Stale data is not as valuable as recent data, or streaming data is perhaps different than static data. And we've seen the open data activities. And so we need to really have that proper frame of reference of what is the data that we're talking about, and then how do we safeguard that data? Now, in the security world, we've had a long history of being able to get certain accommodations because we've safeguarded information in a particular way. So think of credit card numbers and being able to encrypt or obfuscate the credit card numbers and then store them in a database. That's a best practice, and that's the strength of mechanism that's required. With personal data, we get no such accommodation. So encrypted personal data, regardless of strength of mechanism, is still personal information. So we're really constrained with that. And when we think about some of the new tools that are available, things like homomorphic encryption, where you can do operations on two pieces of obfuscated data. Differential privacy, which allows sharing of information in a privacy-friendly way. Confidential computing, which allows you to have information that's protected all the way into the hardware, only opened in the hardware and then shared outwise. We have data perturbation techniques. And so when I think of privacy analytics, a company founded here in Canada by Colette LMM, they do data obfuscation and perturbation. So you can take a data set, and then you can change the dates of birth and then the names of the individuals and perhaps the genders in a statistically relevant way, so that you can work on this data and not release any information. They've taken that a step further, and they can take medical records, wholly identifiable medical records, run it through a machine learning algorithm and create wholly synthetic data. So you can create a completely fictitious data set that has all the same characteristics of the previous data set, but it's completely anonymous. Like how cool is that to be able to do that? Or take that a next step, and there's talks about distributed learning for machine learning. And so when we talk about the broader North American context of being able to have data from this melting pot or the mosaic, depending on what side of the border you're at, of 500 million individuals, to create new medicines, to be able to do more traffic planning or transportation planning. You have these great capabilities. The last piece that fits into this is the governance side of the house as well. So we see data trusts or data collectives or data communes or essentially data sharing activities where you put in place the rules of the road so that you can have these meaningful business contexts and understand how you manage that data across the communities. And so in short, there's a ton of new technologies that are coming out that give us these tremendous capabilities that support us in a privacy enhancing way. And it's a matter of getting people to use those. The last thing, just to close off, is we saw the power of these privacy enhancing tools with our COVID tracking application that's in here in Canada. So be able to have privacy commissioners, experts in industry, civil society review the capabilities of these tool sets, attest to the fact that they are privacy friendly, and then be able to provide a meaningful service. And so privacy by design can be done. And we just need the legislation to recognize that there's these tools and techniques that provide us these new capabilities.
Yeah, it's certainly comforting. I didn't know that there were so many different technologies for the encryption, and we should, Myron, we should get him on the podcast to talk about some of these technologies in more detail, because I think people, I certainly want to learn more about that. But you also touched upon governance there, and I'm going to flip it actually back to Carlos and Myron, because that whole, so the tools are there. And it's important to have those tools, but how do you govern that, and how do you create an accountability framework? So I don't know, Myron, Carlos, I think you both can talk about this. So I let you just, whoever speaks first.
Let me start with that, Myron. Sorry, and I definitely like what John was saying, how he was explaining that, because yes, these regulations come from the time of the Commodore 64. So the computing power we have today is different, and how we are using data today is different. My concern comes when we are talking about governance on the level of involvement that companies have when they are interacting with third parties, and the level of commitment they put to define where the boundaries are and who's going to be responsible for what. In my experience, companies in Canada and in other countries not necessarily devote a lot of time to that. And it is still common to see companies that when they create a relationship with a third party, they limit this relationship to include a couple of clauses in the contract talking about confidentiality, which is not privacy at all, and a very generic clause on privacy. And I think there needs to be more time devoted to it. And we need to understand that in order to properly use all of these wonderful tools, we need to devote time to learn how we are going to be using them and who's going to be responsible for what. I think it is time to have mature and responsible vendors like Microsoft that will take the time to train their users and explain to them how tools can be used and which benefits can be gotten. But of course, on the client side, on the company side, you need to devote some time to define the rules on how that is going to be managed and who's going to be responsible for what. We need to understand that when we have a relationship with a third party, there's a life cycle for that. It is not only something that we need to be paying attention to when the relationship is created. We need to define how we are going to be monitoring that this third party I am working with, that this tool I am using is effectively responding to what I need from the compliance perspective, from the value generation perspective. And when the relationship comes to an end, I need to define in advance the controls I will use in order to have my company and my information safe, and of course to have the vendor safe as well, so that everyone can go to do their businesses with the tranquility that everything is under control. So I think that when it comes to governance, devoting time to creating a solid third-party risk management process is something that is critical.
Yeah, agreed.
Myron, what do you think?
Yeah, no, I totally agree with everything both John and Carlos you both said here. It's absolutely critical that organizations take ownership and an understanding on a stage that happens before you're opening up as privacy, that you start asking questions about what data is going to be processed, what data is going to be stored, and what your obligations are from your customers to you. I think it needs to be more of an early stage discussion, get the right people in the room early to talk about the actual operational limitations and risks here, and responsibilities early to, well, understand if the solution, if the relationship even works from that level. Otherwise, it just becomes a shoehorn exercise in the dying hours of negotiating a contract or a relationship to get something in between that's good enough, right? And it's never a good way to do it, I don't think. And I think organizations just need to take the time to have those discussions early and have an appropriate strategy and third-party risk analysis internally before even moving into those stages. So I think I agree with everyone's comments here.
Yeah, I mean, we've seen, like, through the association, we've got some, we did a few sessions on regulatory change management. And I think there's lots of good tools out there to help with that early stage, dissecting that complexity that you all discussed at the beginning. I think, when I think about this, what I'm kind of concerned with is that monitoring point that Carlos mentioned, and how to make monitoring dynamic afterwards because of the rules and the fact, the certain rules with the opt-in and opt-out, and that that the rules themselves, underlying rules change. So I think that that monitoring piece is the real nut to crack, and the firms that are able to focus and do that well, would be will be, in the forerunners for solving these problems for the FIs.
Yeah. And then, if I may, excuse me, just wanted to say, when it comes to tools, it is important to think that there's no silver bullet. And I like what John was explaining. There's different tools for different purposes, and every single company will have different needs. When we are talking about privacy and personal information protection, or data protection in general, data trust, we need to think that we need to build like a puzzle, and we are going to be needing different pieces in order to bring this puzzle together and deliver the result we are expecting. So I want to say that because when we think of responding to the privacy challenge from the privacy office perspective, it is complicated from time to time to privacy officers to identify the tool they are going to be using to managing privacy. And there's many wonderful tools in the market for that, of course. But I want to say as well that within IT, within cybersecurity, there's many tools that can help comply with many of the things you need to do within the privacy office. So again, I think that we need to consider that dealing with privacy, responding to the privacy challenge, is something you cannot do playing to be the lone ranger. You need to start creating alliances within the organization to take the value you can take from different teams and different disciplines. And this alliance between the privacy officer and the cybersecurity officer is something that every single company needs in order to be effective when defining how you are going to be generating value through responding to this privacy challenge.
Well, and if we could take it up that next level, it's not just privacy and security, it's data governance. And how
Absolutely.
do you, what's the value of data to your organization?
Yeah.
And once you settle on what the data governance model is, then the rest has an easy way to flow through. And then you can start to apply these tools, as you said, where appropriate. I just think about this idea of, putting stuff in the cloud and then removing permissions at the end of it. You're able to provide that life cycle so much better than before, because you can discontinue access to particular assets, have an expiry date, so to speak. As well, there are technologies that allow you to watermark data. So if you extract a particular indices from a database, you can see the heritage of where that's from. So if someone manipulates that data in unique ways that they're not entitled to, you now have the forensic evidence to go back and say, hey, you're breaking the rules from this agreement or this agreement. And so that third-party agreement is important, but having that overall view of, okay, where's my data? What's important to my organization? Managing that across all your businesses does drive that business value and opportunity that you spoke about, Carlos.
Yeah. So communication, I want to emphasize that because there was a recent study we did at the firm that found that security officers and privacy officers were not necessarily good on creating these relationships with other parties. And I think that's a challenge we need to overcome. We need to have solid relationships with different stakeholders in order to be effective for our organization to do what the organization is expecting from us.
Yes, it's good. I just wanted to call to the audience that you can ask questions. We welcome questions. We are nearing the end. I did want to touch a little bit about, we've talked about tools and management and monitoring. How does shadow IT fit into this? Carlos, do you want to kick us off on that discussion on shadow IT?
Yeah. Thank you, Donna. Yes, of course. I think it is a headache, and I think the first challenge that organizations need to overcome is recognizing that this can be affecting them. I think that cloud is fantastic, and the accessibility we have on software as a service solutions and the different X as a service elements that are available out there is amazing. The challenge we have is that they have become very easy to get. And we have seen in many cases companies where someone in isolation, you can name it whatever, someone within the financial department, the marketing department, the human resources department, or any other, decides to go for a solution by him or herself without involving the privacy officer, the security officer, the IT team. So this person, this individual decides to start exchanging information with an external entity that we don't know if is effectively responding to what the organization is needing. And there can be a very good intention behind this, but the challenge is that if we don't properly pay attention to how risk is managed and how the organization is responding to this, instead of complying or generating value, we are going to be increasing risk for the organization. So I think shadow IT is a significant challenge. And just to make it very clear for everyone, when we are talking about shadow IT, we are talking about this phenomenon, this event in which an isolated department makes the decision of going to get a solution from the cloud, from a vendor, without notifying other important players, as I said before, like cybersecurity, privacy, or even the IT department, creating perhaps results, yes, but challenges for the organization as well. I think this is a problem that we need to be facing. Yeah.
If I could just
Please,
pile
John.
onto that one, shadow IT is indeed something to keep an eye out to manage your risk, but you can equally have people that are not following the rules. How many salespeople do we see that extract and keep their own files in Excel or have their own mailing lists and whatnot? And so there are, again, I don't want to say there's a tool for everything, but there are tools to help with that. One of the cultural changes that we see organizations going through as they move to the cloud and become cloud native and really adopt this cloud culture is they more openly provide these tools and platforms for people to build on. And so this big phenomenon we see now of low code, no code development, where you can almost drag and drop to make new business scenarios. We see IT shops and data governance shops working together to provide platforms of safe sandboxes where organizations can work so that it's under a common governance structure, under a common management. Still keep an eye out for those rogue environments, but you find far less of these rogue IT shops popping up and having to play whack-a-mole when you do provide that set of tools that allows you to enable the business.
Yeah, and also education, I think, is absolutely critical at the actual employee level and at the department level. If people aren't aware of what the solutions are, or if departments aren't aware of how things operate, you've got to overcome the learning curve as well of use of it too as well. So if your chosen IT solution is something that's complex and it's going to take many hours for a department to relearn how to use it, maybe there's other conversations that need to be had, or an evaluation of another tool, or an educational time devoted to training your employees how to use that tool.
I agree. Education is so important. We have
so that makes of these, Donna, something that is a people's issue. Sorry, just wanted to say this is a people's issue, and we need to pay attention to people. So just connecting this to your original question, that makes of this again something that is business related issue, a people issue, and because of that, it has to be covered by the entire business. Yeah,
back to the business risk question. So I'm going to show the results of the poll, and then I'm going to give the actually, Reva, if you could put up the answers to the poll, and then I'm going to answer. So in terms of, okay, so we think that the privacy officer is probably the most important, which they probably are. I don't know what your view on that is, maybe Myron. Like, I guess privacy officer has an important role. I think, as we've discussed today, that it's a role of the whole organization.
No, I think you just summed it up there. I think it's in the interest of time. It's in most cases it should be now, and it should be going forward. Everyone should be a key stakeholder in those discussions.
Here's a question. We have two questions at the 11th hour. So the first question is, are there any legacy privacy concepts that no longer have relevance in a cloud context? For example, data localization. John, do you have a view on that, or?
Well, I think it's important to note that when we look at some of the cloud environments, the reason that we have over 100 data centers in over 60 different regions around the world is a recognition that there are different legislative requirements and different treatment of data within particular jurisdictions. And so we see that data within a jurisdiction is much like having a filing cabinet of paper within a jurisdiction. And we would want it to be treated in the very same way from a discovery perspective or lawful access discovery perspective. The laws don't necessarily act that way, and we find that in certain cases there's conflict of laws between different regions. And so, where we have a request for information from one region across another region, we will contest where there's conflicts of laws. And so, I think it's important that we do have these different frame of reference, however, around these architectures of understanding that there's content data, there is derived data, there's diagnostic data, there's telemetry data. Like there's a variety of different pieces of data that are there, and simply having one particular portion around it or one particular mindset around it perhaps causes friction. I think the other piece that often fits into this is because of the data spillages that we see happening out in some of the communities, we tend to react towards, let's say, a large social media provider or whatnot as the representative case for how data should be handled or protected. There are a lot of enterprise grade services where you're providing information internally that fall outside that, and there's different agreements for that. And it's important that we separate and talk about the right thing at the right time, so we have an understanding of the right context. As was mentioned earlier, the different contexts around healthcare, the energy reliability councils, nuclear, and all those things.
Thanks, John. If anybody has any, I'm missing one question from the audience because of time, but if anybody has any questions subsequent to this, please send them to me and I'll get them to the speakers. So to close things out, we've talked a little bit. Well, we've talked a lot today about how important data privacy is to Canadians and the protection of our data. And we've also talked about, the impact that these new legislations could have in terms of our international competitiveness. So if we just go around the group, just really briefly, where do you think we're going to be in 3 to 5 years in Canada? So just a quick first thought, Myron.
So maybe not where we are going to be, but where I hope we would be is in a position where we have a bit more harmonization across the board on requirements, with the understanding that there's going to be certain more sensitive data that needs to be treated differently, but more harmonization to really improve and allow for more competitiveness in the marketplace.
Thank you. John, final remarks.
Myron took mine, so I'm not sure. I think that
sorry for that, John.
I would hope that we use that harmonization for competitive advantage and the global scene. And when I look at the innovation that's happening across Canada in the superclusters or in the artificial intelligence space or even the quantum space, the ability to meaningfully share data in a trusted way is going to differentiate those prosperous companies, those prosperous governments. And so being able to recognize the opportunity that we have by increased data sharing is where I hope we'll be.
Carlos, final remarks.
Thank you. I expect to have Canada recognizing privacy as a human right. I will not repeat what Myron and John have said, but I am definitely in line with that. And I expect to have a country that is seeing privacy as a value generator instead of something that is only demanding compliance considerations. Yeah.
That's perfect. Well, thank you very much for your final comments. Very insightful. And thank you so much for your participation today. Thank you to the audience for attending. And thank you to EY for sponsoring this series of events. And our next session is on AML and looking at model verification, and that's on June 22nd. So please join that. Thank you all and have a good rest of your day.
Thanks,
you.
everyone.
Thanks, everyone.
Take care.
Bye-bye.
Bye-bye.
Thanks. Bye.